denne på? Ok. Skal vi se. Okay, good morning, everyone. It's nice to see that people are finding friends and colleagues to talk to, but the time shows that we should start the program. So I would just like to welcome you all to this event today. My name is Inger Skjelsbæk. I'm a senior or research professor at the Peace Research Institute in Oslo. And I will chair this event this morning. And I'll just say a few words before I give the word to our main speakers. I just want to acknowledge that this is an open session of a two-day seminar or symposium entitled, How Does International Criminal Prosecution of Conflict-Related Sexual Violence Impact Peacebuilding? And this is part of an initiative that has been going on for some years called the Missing Peace Initiative, which is a collaborative project of the Peace Research Institute in Oslo, the Human Rights Center at UC Berkeley, the United States Institute of Peace, and Women in International Peace and Security. Or Women in International Security, I'm sorry. And we had our first event in February of 2013 in Washington, a big symposium, where we gathered scholars, policymakers, practitioners, military and civil society actors to examine the issue of sexual violence in conflict and post-conflict settings. We aim to identify gaps in knowledge and reporting and explore how to increase the effectiveness of current responses to sexual violence. We had also a follow-up symposium in Uganda in 2015 on the same topics. And an explicit aim of this overall initiative is to include findings from the latest academic research, as well as insights from practitioners working in conflict and post-conflict situations, including civil society actors, the military, and the police. And the initiative also established a Missing Peace Young Scholar Network, which was aimed at supporting PhD researchers and recently finished PhDs in their research and the dissemination of research results to the practitioners and policy communities. So we've been now in existence for 5 years, and we're very happy that we now have this symposium here in Oslo, organized by PRIO. And I just want to acknowledge my partners in this endeavor. So if you could just stand up so they can see you. Kathleen Keenest, who is the Director of Gender and Policy Strategy at the United States Institute of Peace. Chantal de Jong Udrat, who is the President of Women in International Security. And Kim Tu Sillinger, who is Director of the Sexual Violence and Accountability Project at the Human Rights Center at UC Berkeley. So thank you for being here, and thank you for making this happen again. And on that note, I will give the word to PRIO's director, Henrik Urdal, who will wish you an even more formal welcome. So the floor is yours.
Thank you very much, Inger, and dear excellencies, guest speakers, participants, and not least organizers of this Missing Peace Symposium. My name is Henrik Urdal, and I'm the director of PRIO since July this year. And it's my great pleasure to welcome you all to this formal opening of the two-day symposium on preventing sexual violence in conflict, Is Fighting Impunity the Only Game in Town? As the International Criminal Tribunal for the former Yugoslavia, the ICTY, is now finishing its work as we speak, this is a particularly suitable moment to address this question. At the time of the Bosnian conflict in the early 1990s, conflict-related sexual violence, or CRSV, was virtually a non-theme in academic analysis and policy circles. It was regarded as simply a byproduct of armed conflict, not a central feature of or element in warfare. This byproduct did not merit close scrutiny or systematic analysis. Hence, we had little understanding of the phenomenon, its complexities, and varied impacts psychologically, socially, culturally, or politically. The wars in the 1990s, notably the ethnic conflicts in Bosnia and Rwanda, changed this perception. Conflict-related sexual violence hallmarked how we came to understand the so-called new wars, where the front lines were blurred and civilians were targets. From having been a hidden and overlooked phenomenon, conflict-related sexual violence increasingly took front and center stage in war reporting, fact-finding, and policymaking in the 2000s. A case in point of recent date, the latest reporting on the devastating situation for the Rohingya population in Myanmar, where reporting of mass rape and sexual violence against women and young girls make international headlines. Also, the adoption of United Nations Security Council Resolution 1325 in 2000 and the pursuant resolutions that make up the so-called Women, Peace and Security Agenda ensured international political leadership and engagement in the prevention and mitigation of CRSV. Arguably, the most important political engagement in CRSV has been international criminal prosecution of these crimes. The ICTY has done groundbreaking work in documenting, prosecuting, and sentencing sexual crimes offenders in armed conflict and has set the standard for other international as well as national courts. Yet the court itself is contested. The aims were high: to create a sense of justice, fight impunity, and clearly show that there is no escape from crimes committed in armed conflict. Perhaps were the aims too high at times? Going from criminal prosecution to a sense of justice is not as straightforward, nor to peace and reconciliation at large. This does not mean that criminal prosecution is a failure or futile. It is an integral part of rewriting what has happened, setting the record straight, and assigning guilt and responsibilities. Sometimes these efforts further peace and reconciliation, and sometimes they do not. The responses to verdicts in the ICTY have shown both. What is clear is that the ICTY, the International Criminal Tribunal for Rwanda, and the International Criminal Court have framed sexual violence crimes within a new paradigm. Conflict-related sexual violence is no longer seen as something that can be paired with collateral damage. It is central to political analysis of war and conflict, and should therefore also be central to political analysis and policies on peace building. How to do this is perhaps less clear. It is clear, however, as is stated in the program, that sexual violence in conflict and post-conflict settings is increasingly recognized as a threat to international peace and security. From conflicts in the Balkans to the Democratic Republic of the Congo, and from East Timor to Guatemala, state and non-state actors have used sexual violence against women, men, and children to intimidate and to terrorize populations, and as a mean of displacing people from contested territory, destroying communities, and silencing victims. Even after wars have ended, sexual violence often does not, which in turn undermines reconstruction efforts and the transition to more stable, secure, and peaceful societies. Despite the increased international recognition of the serious impact that sexual violence in conflict and post-conflict poses to security and peace, initiatives to prevent or mitigate these violent acts contribute to fall short. Even with the adoption of UN Security Council resolutions and important rulings in international criminal courts, existing international interventions may lack an integrated understanding. The Missing Peace initiative, through all its events, have aimed to bring together policymakers, practitioners, and academics to discuss across different spheres of competence and responsibilities. This event is no different, and as a relatively new director at PRIO, I'm particularly happy to see these fruitful conversations take place. This is where PRIO aims to be, making research relevant in the promotion of peace. PRIO has a long-standing research engagement on women, peace and security and on sexual violence in armed conflict. PRIO researchers have engaged in qualitative as well as quantitative research on sexual violence, in documenting stories, events and frequencies. It was PRIO researchers who established the first global database on sexual violence in armed conflict, which documents active conflicts from 1989 throughout 2009, and includes reporting 5 years after the end of conflict. This research was timely and important, and it contributed greatly to new conversations with new audiences, both in academic and policy domains. PRIO has engaged in a collaborative effort with the Panzi Hospital in the DRC, assessing how various CRSV survivors programs have been received. And finally, PRIO researchers have also undertaken research on perpetrators of CRSV, how they are seen by the court, and which stories they tell about what they have done. This is an arena of research where PRIO will stay committed. Finally, I would like to thank our partners and funders to this symposium, the Norwegian Ministry of Foreign Affairs and the British Embassy in Oslo. Thank you. Furthermore, we're very grateful, of course, to the people at the PRIO Center on Gender, Peace and Security for all their work in planning and organizing this event, in particular Julia Hansen, Torgunn Tryggestad and Inger Schelsbeck. Finally, I wish you all a good symposium and some productive conversations. Thank you.
Thank you very much, Henrik. Now we move on to one of our funders. We are very happy to introduce Marianne Hagen, who is the State Secretary at the Norwegian Ministry of Foreign Affairs. Hagen was appointed State Secretary not so long ago, and previously to this appointment she was Communications Director for the Royal House of Norway from 2008 to 2017. And other previous positions include advisor to the CEO of the Norwegian Ship Owners Associations, economic policy advisor to the Norwegian Ship Owners Associations again, and political secretary for Høyre, the party Høyre. And we're very, very happy to have you here, even in your first position, and give the floor to you. Thank you.
Excellencies, ladies and gentlemen, colleagues and friends. This is a major call to action to end the agonizing abuse. Children being raped, girls being impregnated by the enemy, women being violated in front of their families. Gradually, the devastating stories of the women are being echoed by stories by men. Different, but the same. Physical and mental wounds, shame and loneliness, unbearable pain. Every single day, sexual violence is used as a weapon of war. Domestic violence increases as tension grows. The chaos of conflict prepares the ground for new, unreported, unprosecuted abuse. The persisting impunity is intolerable. The numbing stigma must be dealt with, the pain that continues long after the gunfire has ceased. Somehow, we still treat rape as a burden the woman herself must carry, while a gunshot wound is a matter of national security. And yet, rape tears families and communities apart just as effectively as bullets do. Sexual violence erodes the societies we're striving to stabilize and rebuild. It destroys the future as well as the present for many more than the women and the girls, the men and the boys who are directly affected. If we are to ensure we're not missing peace, preventing sexual violence should be at the very forefront of our efforts. I am pleased to say that this is the case for Norway. Preventing and responding to sexual violence is a cross-cutting priority in all our peace and security efforts. We deploy many women police officers to international operations, and we are working to increase the number of women in our military contingents, because we want to recruit the best, irrespective of gender. A diverse team delivers better on the ground. We want our men to speak out too. Gender is never only about women, and sexual violence cannot be stopped by women alone. We train our personnel well to ensure that those who are entrusted with people's lives can in fact be trusted. We have good cases examples to showcase, such as the special team in Haiti. They're working with Haitian police to develop better responses to sexual violence, from registering a case to prosecuting the crime. We cooperate with the African Union in the Training for Peace program and with the Special Envoy Diop's office. In close cooperation with the UN, we are developing a whole of mission handbook for UN operations on how to prevent and respond to sexual violence in conflict. We are looking forward to launching it next year. We are strengthening the gender perspective in our humanitarian efforts, asking more of our implementing partners and monitoring their work better. We will develop a new humanitarian strategy with a strong focus on gender. And we are renewing our partnership with Special Representative Patten's office, because we know we need the UN to lead and coordinate our response. Our civil society partners run shelters, provide psychosocial and legal support, and engage in livelihoods programs. In mediation, we work to ensure that the victims are heard. The amnesty for sexual crimes is not accepted. We learned through the Colombia process that this is possible with the commitment of the parties and a strong push from civil society. I'm proud of Norway's effort, but we all have a way to go. We must design our efforts better and coordinate them more effectively. We commend the work of the UK to this end. Sexual violence must be included in ceasefire agreements. It must be on the table in peace negotiations. It must be part of our analysis and in the forefront in our peacekeeping. This should not be the exception. It should be the rule. And when we have been unable to prevent sexual abuse, our approach must be centered on those who have suffered the crime. We must fight the stigma while providing support and justice. It's time to move from monitoring to prosecuting. Our response to conflict-related sexual violence needs to be as varied as its causes. If discipline is the problem, we should offer capacity building and technical support. If the use of sexual violence by armed forces is intentional, this needs to be addressed head-on. Irrespective of cause and context, we cannot accept impunity. States have a duty to prevent as well as investigate and prosecute. The perpetrators must be held responsible, and their leaders, military or civilian, must be held to account, even if, and especially if, they are leaders of UN peace operations. Leaders must have incentives to take action. And even more importantly, inaction must have consequences. As the main global provider of peacekeepers, the UN has set high standards. These standards must be upheld. The Security Council resolutions on women, peace and security have provided a robust normative framework, which calls for an end to impunity for sexual violence and for greater national accountability. The Rome Statute was an important milestone. The work of the International Crime Court merits widespread recognition. Justice and the legal order are increasingly recognized as prerequisites for lasting peace and stability. ICC judgment has achieved justice for many victims. We appreciate the prosecutors' continued focus on sexual and gender-based crimes and crimes against children. Some of you might have seen the film The Uncondemned, which is set in Rwanda. It demonstrates that progress is possible and justice can be attained. However, it also demonstrates how power protects perpetrators, how hard it is to access evidence that will hold in court without re-victimizing those who have already suffered too much, and what courage it takes to reach a conviction. Today's discussions is not about victims. It's about survivors, resourceful women, men, and children. They must be protected. They are entitled to justice. And we need their participation if we are to build resilience and peace. They must be enabled to take part in rebuilding their societies. Some of the people who can truly make a difference are here today. I'm honored to be sharing the podium with the UN Secretary General, Special Representative of Sexual Violence in Conflict, Pramila Patten. We are pleased to be partnering with you and your office. And we appreciate the long-standing cooperation with the African Union and the leadership of Ms. Diop. We value and we have high hopes for your work, but we know you cannot end sexual violence or impunity on your own. None of us escapes responsibility. Everyone has an opportunity to make a difference. This is why we are here, to take a closer look at what we can do, how we can address sexual violence in such a way that peace can be achieved and sustained. Thank you.
Thank you very much, Marianne Hagen. And I think I should have rephrased and not introduced you as a funder, but collaborating partner in this endeavor. It is with great pleasure that I now give the floor to Under Secretary General and Special Representative on Sexual Violence in Conflict, Pramila Patten. Ms. Patten has had or prior to this appointment, I think you are the third in this position. But before this, Ms. Patten served as a member of the Committee on the Elimination of All Forms of Discrimination Against Women. She has been the member of several high-level panels and projects, including the high-level advisory group for the global study on implementation of Security Council Resolution 1325. On women, peace, and security, and on the advisory panel for the African Women's Rights Observatory within the United Nations Economic Commission for Africa, and many other positions. And if I were to read them all, we would have no time to listen to Ms. Patten. So I give the floor to you. Thank you.
Good morning to all. Excellencies, ladies and gentlemen, good morning. I'm truly delighted to be here in Oslo this morning to participate in the Missing Peace Symposium. And I would like to take this opportunity to thank and to commend the co-organizers of this very important event, namely the Peace Research Institute, the United States Institute for Peace, the Human Rights Center at the University of California, Berkeley, and Women in International Security. I would also like to express my deep appreciation to the government of Norway and to the United Kingdom for supporting this symposium and for being such steadfast champions of my mandate. As some of you may know, my mandate as Special Representative of the Secretary General on Sexual Violence in Conflict was created by United Nations Security Council Resolution 1888, adopted in September of 2009. And this was truly a milestone in the global recognition of sexual violence as a tactic of war and terror, as a threat to collective security, and an impediment to the maintenance or restoration of peace and the rule of law. As you rightly pointed out, Madam Secretary of State, it was an unequivocal call to action. Action against a long historical backdrop of wartime rape being invisible and shrouded in silence. Some council members described the role of the special representative as being a voice of the voiceless. The focus of this symposium is on the links between combating impunity for conflict-related sexual violence and the broader goal of building peace. While we can question the impact of prosecuting international crimes on the maintenance and restoration of peace, what we cannot question is that impunity fuels the vicious cycle of violence. Impunity is tantamount to a license to rape. Throughout history, the reign of silence, impunity, and denial has meant that these crimes continued unabated, resulting in sexual violence being deemed the world's least condemned war crime. The survivors I met, from women in Eastern DRC to the Chibok girls in Nigeria, survivors of sexual slavery in Bosnia and Herzegovina, to members of the Iraqi Yazidi community, and most recently, 2 weeks ago, Rohingya women and girls who have fled their ancestral homeland in Myanmar, they all had a very clear message. They not only wanted, but needed that the perpetrators be punished to ensure their own personal safety, to be able to return to their communities and to begin to heal. They all expressed a thirst for justice as urgent as their needs for health services, education, livelihood opportunities, and psychosocial support. Indeed, these interventions are not mutually exclusive. They are mutually reinforcing. Women have no rights if those who violate their rights go unpunished. Listening to the voices and perspectives of survivors of conflict-related sexual violence since I took up office in June has really shaped my own strategic priorities for this mandate. And a strong component of my vision for the mandate is really to translate accountability into deterrence and behavioral change and prosecution into prevention. In recent decades, we have seen major milestones in the quest for gender justice. The jurisprudence of the International Criminal Tribunals for Rwanda and the former Yugoslavia, as well as the Special Court for Sierra Leone and the International Criminal Court, have all recognized the gravity of sexual violence as a war crime, a crime against humanity, and an act of genocide. There have also been historic developments at the national level in countries like Guatemala, Guinea, Colombia, and elsewhere. Nonetheless, the fact remains that we have not yet reached the tipping point at which fear of accountability effectively restrains the behavior of combatants. Accountability indeed must become the rule rather than the rare exception. International courts and tribunals must cast a long shadow, ultimately changing the I'm sorry. Accountability must really become the rule, and I think we all have a role to play in that rather than being the rare exception that it actually is now. And I think international courts and tribunals must really cast this long shadow, ultimately changing the calculation that has made rape a cheap and effective weapon of war and terror. And I think that ultimately it is really through the consistent and predictable application of justice that we will be able to convert cultures of impunity into cultures of deterrence and really break the vicious cycle of violence, impunity, and revenge. The sense of impunity and entitlement that prevails amongst armed groups in the lawlessness of war exacerbates pre-existing gender-based discrimination. And indeed, structural gender-based discrimination is the invisible driver of these crimes in times of war and in times of peace. We see how women are disproportionately affected due to their lack of economic and social capital and their lack of representation on the front lines of law enforcement throughout the justice and security sector, and also in the upper echelons of political power. Unfortunately, we see time and time again that the lower women's status in terms of health, wealth, and education, the greater their exposure to harm and to violence. So that if we seek to transform the underlying conditions that give rise to successive waves of conflict, then our response must really be to deliver justice, not just law. And this means fostering equality and social justice in the community, not only in the courtroom. And beyond punishing the perpetrators, it is also important to take a holistic and survivor-centered approach. For instance, we should not ignore the fact that reparative justice is the response that survivors want most, yet receive least. I believe that when justice is done and seen to be done, it has great transformative power. It has the power not only to provide redress for past wrongs, but the power to change the future, the power to prevent. And my mandate includes efforts to build capacity at the national level through my team of experts on the rule of law, working out of my office. And the team of experts has actually supported many governments. One concrete example would be the government of DRC to set out, for example, a roadmap for comprehensively addressing sexual violence, including by prioritizing key cases for prosecution, training and supporting women magistrates to hear these cases, and monitoring trials, including that of the notorious warlord Sheka, who is charged with command responsibility for the mass rape of 387 civilians in Walikale in 2010. Similarly, following the politically motivated mass rape of 109 women in Guinea-Conakry in September 2009, 17 high-level government and military officials have been indicted, including former President Moussa Dadis Camara, following strategic support and deployment of dedicated expertise by my office. My office has also signed joint communique with a number of countries, including Iraq, the DRC, South Sudan, and Côte d'Ivoire, to support national-led efforts to strengthen accountability. In too many settings, survivors risk being twice victimized, first by the perpetrator, then again by society and the state, which is often unresponsive, sometimes even punitive and discriminatory. And in many conflict settings, the pace of justice can be painfully slow. As you mentioned, Madam Secretary, rape is still the only crime for which a society is more likely to stigmatize the victim than to punish the perpetrator. And I think we all have a role to play in reversing and redirecting this stigma, to send a clear signal that the only shame of rape is in committing, commanding, and condoning it. Conflict recovery is not only about rebuilding homes and infrastructure. It is fundamentally about rebuilding trust and tackling the stigma associated with sexual violence and supporting the socio-economic reintegration of survivors must really infuse all our strategies and programs from the outset. The first step is to recognize that victims of wartime sexual violence are legitimate victims of war. They are entitled to equality before the law and to the same status, public sympathy, reparations, and redress as any other war veteran or victim. And this is critical in light of lingering public perceptions that rape is somehow a lesser crime. We must recall that wars are not just fought, they are told, and the telling is steeped in relations of power. It is therefore critical to prevent sexual violence from being minimized and trivialized in the conflict narratives that are passed down to future generations. Never again should we underestimate the devastating impact and lasting legacy of these crimes. Through annual reports on conflict-related sexual violence compiled by my office since 2009, we have built a public historical record for a crime too often met with denial and even derision. For many survivors of conflict-related sexual violence, war is not over when it's over. It lives on in trauma, depression, unemployment, poor health, and hidden children who are relegated to the margins of society. Peace is not just the absence of war, but the presence of peace of mind. Therefore, any investment in comprehensive services, including access to justice for survivors, is also an investment in peace. And I'm glad that my office is contributing to this cause, and you can rest assured that we will continue to do so. Allow me to end by emphasizing that addressing sexual violence is a matter of human rights and dignity, which are universal. No perpetrator is above the law, and no victim is beneath the scope of its protection. I believe that combating impunity for crimes of conflict-related sexual violence is integral to building a durable and inclusive peace, and to ensuring that the dividends of peace flow equally to women and girls. Justice can be a transformative force. It can help to turn victims into survivors and survivors into agents of recovery and reconciliation. I thank you for the opportunity to share these reflections, and I very much look forward to a fruitful and thought-provoking symposium. Thank you.
Thank you very, very much. We are in no doubt that the UN is heavily committed on this issue through both you, your office, and your work. So thank you very much for that. We're moving now on to a different part of the program. We're going to have a panel. We're actually going to have one more keynote speaker, but the keynote speaker is at this moment on a plane, we think, or maybe he has landed. So he will have his keynote address at the end. So, but we will start with the panel discussion. And I think I will ask the panelists to simply step up here and take a seat. And Ms. Patten, if you would like to sit here too. And then I will introduce you in due course. Okay. Have people had a little coffee refill and some extra water if needed? Then I think we're ready to start again. We have a panel of very distinguished speakers here. And I don't know if you prefer to sit while speaking or if you want to stand up. It's up to you. But I will nevertheless introduce you. Bineta Diop is our first speaker. Bineta has already been mentioned by several. She is currently the special envoy of the chairperson of the African Union Commission on Women, Peace and Security. She is the founder and president of Femmes Africa Solidarité, an international NGO that seeks to foster, strengthen and promote the leadership role of women in conflict prevention, management and resolution in Africa. She played an instrumental role in achieving gender parity within the African Union Commission's leadership and in the adoption of the Solemn Declaration on Gender Equality in Africa, as well as the Protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa. And one more thing to note about Ms. Diop is that she was recognized as one of the 100 most influential people in the world by Time magazine in 2011. So we are very, very happy to have you here. And the floor is yours. Do you prefer to sit, Diop, or would you like to stand? You can sit.
We sit. Thank you so much. And I'm so glad to be here today with Priyo because Turan, I have been not the first time, but I think I can't name the numbers, and being with you, it's great to be in Oslo again. You're doing a wonderful job. We want to congratulate you. And also to the Norwegian government, because I think that, as was mentioned this morning, that the work that we are doing, my sister, the special representative of the UN, Pramila Patten, being the voice of the voiceless, I think that we have been doing that, and the support of the Norwegian. And I appreciate very much that support as well. So I'm very glad in seeing this room full of activists, the doers and the makers, the researchers and the universities and government, the policies makers. I'm very glad. And also let me say that I'm here with Dr. Thelma Awori, who was the UNDP Director for Africa, one time from Uganda, who is working on this particular subject on violence against women in Africa as well. Having said that, I think we set the tone this morning, and I just wanted to share few experiences because my work is on the ground. Is really to ensure that those that have been affected, the issues that they experience are brought to the policymakers, but also we find solutions for them. I started with the Tribunal of Rwanda, which is you might recall that in 1996, the first tribunal, the International Criminal Tribunal for Rwanda, charged a man called Akayesu with genocide, complicity in genocide, and also, I mean, there was a lot of charges, but one of it was the rape issues. And it was for us in Africa the first time that we brought to justice by an international tribunal the 1948 Genocide Convention that rape considered as inside the constitutive of genocide, that we say that it is part of that in the tribunals and the Genocide Convention. And it consequently, you know, the case have to be taken into consideration, the rape that have happened. So another process that we started in Africa, you name it, is that the Maputo Protocol, which is very strong, which says that in Article 11, protection of women in armed conflict, state party, and I quote, undertake to protect asylum-seeking women, refugees, returnees, internally displaced against all forms of violence, rape, and other forms of sexual exploitation, and to ensure that such acts are considered war crimes, genocide, and crimes against humanity, and their perpetrators are brought to justice before a competent criminal jurisdiction. So the law is very clear, and many countries in Africa have adopted the Maputo Protocol. But as you could see, despite all this, the existing provision, violence against women has continued in many conflict situations. Women are targeted. That's the reality. And justice is not there. I mean, Rwanda was an exception. And when you look at the Hissène Habré court in my country, Senegal, where the women have been asking for justice as well, I mean, we had to push the door to make sure that it was part of the trial. And we could see in the Central African Republic, I visited that country many times, where the women, Muslim and Christian, are together looking for justice. But yet, even though we documented the Human Rights Watch document, 305 cases of rape and sexual slavery carried out against 260 women and girls by members of armed group between 2013 and mid-2017. I met many of them. I listened to them, those who have been raped. But no justice been done. I mean, even don't talk about how do we do the new tribunal if it happened. Even at the national, after the election, what happened to those women that continue to be raped? That's the reality. I think in the Security Council report recently, the UN Secretary General indicate that in 2015, 2,527 cases of conflict-related sexual violence were documented in the CAR, Central African Republic. I think that Pramila have been looking at that, those cases. In March 2016, the Ministry of Justice issued a circular requiring sentence for sexual violence crime to be upgraded from correctional to criminal sanction to provide a stronger deterrent. But this is the lobby of the women. You know, we facilitate the creation of something we call Planet Farm, which contribute to the women, the dialogue, and brought those issues into dialogue of CAR before the elections. I was there facilitating this movement because you need to have the pressure group to continue to pressure the government so justice have to be done. South Sudan. I spent 6 months when I started my mandate as a special envoy in South Sudan within the Commission of Inquiry with President Obasanjo. I was one of the commission. 2 women, a judge, myself, and 3 men. We spent a long time to investigate. And I can tell you that what I have seen in South Sudan, and it continued to happen. You cannot describe it. Women are living as in the camps, as can't describe even the condition. Very difficult situation. But we document in that report, we stood with the women, we stand with them, we document their stories. Horrible. But yet, and we recommend that a hybrid court be put in place and rape be part of the prosecution, that for us it was even the priority areas to address in South Sudan. If we don't do justice, reconciliation will never happen. The women told us that why they just see again the war coming back after they fought their independence with Sudan. It was because they said that when we fought Sudan to have our independence, we came back and we never asked for justice. We say it's done. We have peace, that's it. But we never address the issues, this justice. So we need to listen to the women that, yes, reconciliation, but we need also to look into the justice issue. Otherwise, it will relapse. And that's the case of South Sudan in particular. They were the one telling me this. So we need the international community And we, all of us, Africa, Europe, internationally, we need to say that we need the setting of the hybrid court. Because from our recommendation of the report, it has been also put within the negotiation. It's part of the agreement, but yet it's not yet implemented. I'm sure that tomorrow we will talk about the specific case of South Sudan, how the women came at the table of negotiation, they pushed the door, but also how their issues have been taken into consideration in the agreement, but yet not implemented. So I think that if you take those two cases, either in South Sudan or you take any of them, Somalia, I was in Somalia as well, to talk with the women in the Somalia, and we know that what Al-Shabaab and others are doing there. My sister Pramila and myself and Amina Mohammed and Pumzile of UN Women, we did a joint mission. We were in visiting Boko Haram areas, met with the Chibok girls who returned, but also we sit down with many returnees women's group in Maiduguri, which is the northern of Nigeria. We went also to DRC, and before that I went to what we call the Triangle of Death, Bunya, Beni, which is really the three areas where women have been just slaughtered, just cut the head. Anybody, you know, but the rape is every single day, massive. We went to East Congo, both of us, 4 of us, as African women, but also the 2 institutions, very strong. We meet with the president of the Republic, DRC, but also we met with the women. And what Pramila have said is also the reconstruction, because we need also to put resources. It's not just the reconstruction by having the tribunal, the law, it has to be first, but also reconstruction of the body and the mind of the women. What Dr. Mukwege is doing, but also we have Sofe Padi, which I inaugurated the small hospital in the East, which is great, done by women themselves. What they do is they really support. It's like a one-stop center where they will provide investigation, lawyers, but also support in terms of taking you to tribunal, supporting you, but also psycho support. And I think that this is where we need to put a lot of resources. In my office, I will talk about it, we're doing few programs. One of it with the UK, for example, we supported training of personnel, military personnel on the zero tolerance policy, and I will share some information with you with some centers in Africa. We train women in mediation as well, with the Kofi Annan, with the Pan-African Center in Dakar. But what I'm really trying to do is accountability process at the African Union with the Peace and Security Council. This is the first draft of a framework for reporting. We are saying we need indicators. What is happening, the case. We need to document it in Africa, make our member state accountable. And this framework will help us, which is requested by the Peace and Security Council, which look into the 3 pillars of 1325, including this. This framework will help us to report annually to the Peace and Security Council and share our finding to the Security Council in New York. So for me, it's a priority, the accountability of our member state, bring it to say this is happening on the ground from the women's group. We just ended last week with the support of Norwegian and other partners in ECOWAS, because we wanted to bring it down to the region in ECOWAS to look at the indicators, but also we will next go to the IGAD and other places, SADC, and make sure that all member states have the right indicators for reporting. Because when we say what is women, peace and security, we receive annual report, but it's missing. Nobody tell us how they're addressing the plan of action. Everybody have a beautiful plan of action. We have 19 plan of action in Africa now, and we are getting more. SADC is engaging in this. But implementation, what have you done with that? Nobody knows how. Participation, participation, we did government and so on. Military, it's still something we don't know. So we need to make sure that they go look on implementation and report back to the Peace and Security Council. So my office is doing that, and some member states are really, lots of them are with us, and I think that by next year we will have the second report. This is just the first report of the AU, so it's just a starting point based on these indicators, and we will be making sure that Africa also produce a women, peace and security report that can be shared with the international community. So I stop here, and sorry if I have been too long. Thank you.
Thank you very much. I think we will move on to the next speaker, Christine Chinkin. She's Emerita Professor of International Law and Founding Director of the Center for Women, Peace and Security at the London School of Economics. And Professor Chinkin's work focuses on international human rights law, in particular the human rights of women. She was scientific advisor to the Council of Europe committee that drafted the 2011 Convention on Violence Against Women and Domestic Violence. And she's a member of the Human Rights Advisory Panel, or was a member of the Human Rights Advisory Panel from 2009 to 2016. And she has also, like all the speakers, many more achievements, but I think I will limit myself here in my introduction and give the word to you. Christine.
Thank you very much indeed for that introduction, and also for the invitation to be here today. It's a great honor. It's great to see friends from PRIO again and many other friends, and sit on this very illustrious panel is also a great honor. I'm picking up in some ways from where both Madame Diop and Pramila Patten issues that they have already raised, because the point that I really wanted to emphasize is that the concept of criminal prosecution for peace building must be seen in the broader context of the United Nations Security Council's Women, Peace and Security agenda. Clearly, the pillars relating to prevention of and protection against sexual violence in armed conflict, but also, and I think this is very much where in some ways you were finishing, also the other pillars, the pillars relating to participation and the pillar relating to relief and recovery, which are intimately connected with the concept of peace building, except, of course, that they must be seen, understood, and implemented fully. But I think it's also important that we tend to see the Women, Peace and Security agenda too often as simply a security agenda, whereas it was certainly in its origins, and I think we have to hang on to this, also very much a human rights agenda. And as well as reporting to the Security Council on the one hand, I think there's the importance of keeping the human rights bodies in that loop as well. And this has been emphasized very much by the CEDAW committee, and to quote it in words that Pramila knows too well, because I think you wrote them, is to quote from the General Recommendation number 30, as all the areas of concern addressed in these resolutions, the Women, Peace and Security resolutions, find expression in the substantive provisions of the CEDAW Convention, their implementation must be premised on a model of substantive equality and cover all rights enshrined in the Convention. And the committee reiterates what speakers have said this morning, the need for a concerted and integrated approach that places the implementation of the Women, Peace and Security agenda into the broader framework of implementation of the CEDAW Convention and the optional protocol. And I think one of the problems is this sort of categorization and compartmentalization of these different agendas instead of seeing them as integrated. So what I'm going to do in my brief minutes is explore just a few aspects of the interrelationship between human rights and post-conflict criminal justice, and how, therefore, to enhance the impact of criminal prosecution on peace building, which I think also looks forward to a number of the other agenda items throughout the symposium. We've heard a lot about Africa and Bosnia. I was going to make my first point through brief reference to Timor-Leste. Timor-Leste is a situation where, again, there was an internationalized hybrid court process, the special panels of the Dili District Court. The Dili District Court was created by UNTAYET in the year 2000. It had jurisdiction to try cases of serious criminal offences, including sexual offences, genocide, war crimes, and crimes against humanity, which took place in what was then East Timor between the 1st of January and the 24th of October 1999. This is a very limited temporal jurisdiction, and I think it highlights how which crimes committed by which perpetrators and how the conflict itself is identified and which part of the conflict is made subject to criminal process leads to privileging some victims and therefore some perpetrators over others, has the potential to continue social divides and therefore undermines long-term peace building. So in East Timor, the jurisdictional timeline focused only on the violence that had occurred in that brief period in 1999, the violence that exploded following the Timorese vote for self-determination, and the sort of brief moment following that referendum, and which certainly at that point included the abduction of women, transport across the border into West Timor, where they were raped daily, treated as chattels, forced to perform household chores. But it excluded, and for political reasons, the offences that took place throughout the long Indonesian occupation following the invasion in 1975, and also violence that occurred in the brief moment just before, political violence, sexual violence, in the brief moment before the Indonesian occupation in 1975. These are political choices, and it may well be that the political choice to exclude the period of occupation from criminal prosecution furthered peace building with Indonesia, but whether it furthered peace building within East Timor is another question. And so peace building has multiple aspects itself within and across different communities. Now in East Timor, now Timor-Leste, criminal processes didn't stand alone, and there were other post-conflict peace building initiatives, including a Commission for Reception, Truth and Reconciliation, and the Indonesia Timor-Leste Commission of Truth and Friendship. 2015, which is a good 10 years plus after these various institutions had finished their work, the CEDAW Committee, in its concluding observations to the country, noted that survivors of rape, sexual slavery, and other forms of sexual violence committed during the Indonesian occupation in 1999 still continue to experience social stigma, ostracism, shame, limited access to medical, psychological, reproductive, and medical health systems. And further, criminal processes relating to sexual violence in conflict, however one defines the actual period of conflict, cannot, of course, address, as again the speakers have been saying, the root causes of that conflict, and exclude those who experience such violence in the post-conflict space, privileging in some ways what are recognized as conflict-affected crimes, over what is regarded as the ordinary violence of peacetime, post-conflict, including, of course, domestic violence. And the linkage then between continuing forms of violence that are still rooted in the conflict in this post-conflict space and peace building, I think, has to be further explored. In its shadow report to CEDAW, the main women's network in Timor-Leste told the committee that despite assertions of equality in the constitutional legal framework, women and girls in Timor-Leste face and experience various forms of discriminations, inequalities, violence, social injustice in their daily and public life. But they also went on to emphasize how the present remains affected by the past, that there remains what they called a dark memory regarding the real fate of their family members who were disappeared by the Indonesian military during the occupation. Now, human rights institutions over the last sort of few years, global and regional, have highlighted this concept of a right to truth, not only for the families of victims, but also for the general public who have a right to know what occurred. So in the words of the former UN Secretary General, the right to truth implies knowing the full and complete truth about the violations and the events that transpired, their specific circumstances, and who participated in them. I would add that it also requires addressing both the continuum of violence from conflict, post-conflict, pre-conflict, that entire cycle, and the multiple manifestations throughout this various cycle, so that the right to truth encompasses itself a concept of sexual violence. I'm about to leave East Timor, but I just have a brief side story, which I think is also very relevant to the themes of this symposium. I was involved back in 2000 with Patty in a People's Tribunal, which related to the issue of the so-called comfort women from World War II and their sexual violence committed against them during the occupation of most of Asia by the Japanese military. Now, this, of course, is another situation where there has never been any criminal process addressing the issue of the comfort women. And again, I think it illustrates the long-term impact on peace building of failure to do this. It's still a major issue between South Korea and Japan, and inhibits those countries from moving forward in various other ways. But the story I was going to say about the Women's Tribunal, which again I think shows the continuing effect of such sexual violence, is that there were two women, former comfort women, from East Timor who came to the tribunal. I think they were among the most dramatic. Yeah, I can still picture them. I think the entire village had given their best clothing for them to arrive in Japan. But the interesting thing was that when the tribunal was being designed, East Timor wasn't on the radar. Nobody knew anything about comfort women in East Timor. It only came to light, and just the sort of coincidence of timing, that the 1999 events, and the tribunal was in 2000, investigators had gone into East Timor asking about the violence committed by the Indonesian military during that 99 period. These elderly women basically said, what do you mean the Indonesians? What the Japanese did is what you really want to be investigating. And from that came to the People's Tribunal. And if we're looking at missing pieces, I think People's Tribunals are another aspect that we ought to be developing. Just a last sort of couple of points. Rwanda has been mentioned a good deal this morning. In its concluding comments to Rwanda in 2017, the CEDAW committee observed that gang rape and other forms of sexual violence against women had been documented as having been committed by the Rwandan armed forces in the territory of the DRC between 1993 and 2003, so in the post-genocide period, and without any investigation by the Rwandan government. The CEDAW committee repeated what has been said a good deal this morning: passive acquiescence to past violence reinforces the culture of silence, impunity, and stigmatization. And its obligations under the Convention require it to address all violations of women's rights. And that, I think, is what I just want to emphasize, that adopting a human rights approach alongside criminal proceedings requires attention to the entire canon of human rights. Lip service is paid to human rights in peace agreements, and indeed they are often part of the central text and core of constitution making, which is essentially the blueprint for peace building within a so-called post-conflict society. But this very rarely incorporates economic and social rights. And indeed, peace building too often continues in accordance with the current neoliberal assumptions of cuts to public spending, privatization, and austerity. Economic and social rights are too often discounted as having a role in fighting impunity, and criminal processes are limited by their focus on what are called the large-scale abuses, understood as violations of the right to life, torture, rape, extermination, all the aspects that we're talking about, but without taking into account how gross violations of economic and social rights have often contributed to the situation that has led to the conflict and the ensuing violence. So without the empowerment that is provided by equal access to and delivery of economic and social rights through national legal frameworks in conjunction with criminal processes, I believe sustainable peace cannot be achieved. And so without access to social and economic entitlements, healthcare, shelter, safe education facilities for women's children, livelihood, especially in the demographic change associated with conflict, and particularly with respect to the particularly vulnerable situation of widows, of displaced persons, of those with disabilities, survivors of and witnesses to wartime atrocities. All of these people are less likely to be able to participate in criminal processes or to be able to make informed decisions about what particular path towards justice they themselves should choose. And I think the same is true about participation in peace processes. Peace processes are the important forerunner of subsequent criminal processes. And research has shown, and Madame Diop has just referred to it as well, that where women are involved in peace processes, there's a higher likelihood of courts, criminal justice being incorporated into the post-conflict peace building. So that an inclusion of all four pillars of women, peace and security, with everything that you have just said, the need for indicators, the need for proper reporting and monitoring and implementation, are, I think, important ingredients of the missing pieces to peace building. Thank you.
Thank you so much. I think we'll move straight on also now to the last speaker, Patricia Sellers. She is an international criminal lawyer. She is the special advisor for prosecution strategies for the prosecutor of the International Criminal Court, and was recently appointed special advisor for gender to the Office of the Prosecutor of the ICC. Ms. Sellers is a visiting fellow at Kellogg College at the University of Oxford, where she teaches international criminal law and human rights law. And she was the legal advisor for gender, acting head of the legal advisory section and prosecutor at the ICTY, the Yugoslav Tribunal, from 1994 till 2007. So the floor is yours.
Right. Thank you very much, and thank you very much for the invitation. I would really like to honor Prio University of California, United States Institute of Peace, because you have kept a sustained conversation. Too often, during the past 25 years, there'll be a conference that will discuss sexual violence by an institution, and it is basically a one-off event. And then they'll go back and laud themselves for the previous or the next 10 years about, didn't we hold a great conference? But you've taken, really, the courageous stance of engaging in a long-term discussion. And this is what's needed. It's needed to allow ourselves to state issues, to question issues, and to evolve in our thinking and to restate issues. So I just want to say, really, a profound thank you for taking this issue serious enough that the conversation continues. Well, I'd like to start by saying that the Yugoslav Tribunal, and as a matter of fact, the Rwandan Tribunal, were created under Chapter 7 of the UN Charter. And we know that Chapter 7, the highest actions that the Security Council can take, meant that, in particular, the Yugoslav Tribunal was set up in order to reestablish the peace. We noticed that because of the armed conflict in the former Yugoslavia, that there had been a breach in the peace. And so, lo and behold, we set up a court to reestablish the peace. And then when the Rwanda Tribunal was set up 18 months later, possibly and probably because they had set up the Yugoslav Tribunal, that they could not let a genocide be unattended, that again it was to restore the peace. And I think it's very important how we look at peace in those two situations from the Security Council's point of view, even putting aside a little bit of the politics, is that the Security Council basically said that there is a breach in the peace when there is armed conflict, and there is a breach in the peace when there is genocide, which is a non-armed conflict situation per se. I'll get back to that a little bit later in my presentation, and I want to turn to more recent events in terms of restoring the peace or understanding there was a breach of the peace in the former Yugoslavia. As we know, last month, Radovan Karadzic was convicted. He was convicted of genocide as related to the Srebrenica massacres, and he was convicted of crimes against humanity and war crimes, in particular during the takeovers of several municipalities within the former Yugoslavia, and he was also convicted for, in quotes, what is called the Siege of Sarajevo. Well, what I want to highlight about those convictions, in case you have not been able to read through the 5 volumes of the judgment yet, and I'll confess I haven't either. I've done a lot of searching for where sexual assault or rape appears. But what is quite noticeable with Mr. Mladic is that now he joins quite an esteemed group of nefarious people, meaning the other presidents of the former Yugoslavia, Plavšić, Krajčnik, and Karadzic, and he as the top military person, for being responsible for sexual violence that occurred, in particular during the takeovers of the different municipalities in the former Yugoslavia. Well, one could say, well, we've been looking at Yugoslavia and sexual violence for 25 years. What's new about this? As a matter of fact, we're getting a little bit bored about the success, right? Well, we should really pierce the veil and look closer. Within the Mladic holdings and findings, we see that Mladic himself participated in what was called a joint criminal enterprise, meaning that he intended, along with Plavšić, along with Krajčnik, along with Karadzic, to persecute Bosnian Croats, Bosnian Muslims, and among the means and manners in which he persecuted was deportation and detention. And among the means and manners that this persecution was carried out was via sexual violence. It's very important to understand that persecution can be implemented by sexual violence. Well, who did he persecute? He persecuted females, both girls and women, and he persecuted males, both boys and men, via sexual violence. They bring out, in particular within the Mladic decision, the men that were sexually assaulted in the Batkovic camp. They also bring out, in particular, the sexual violence that occurred in the Foča community, which is very well known through the Kunarac decision, but it goes much more into depth about girls and women being held in houses that one says as a misnomer, houses of ill repute or prostitution. Well, you would say, well, that's fine and good, but let's be quite honest about this. He did not write a policy to sexually assault the women in Foča, and he certainly didn't come down to Karaman's house and physically partake in any of the sexual assaults. It's very interesting within the evidence of General Mladic. They have found his diaries where he himself knew of specific women who were kept in these houses and of men who belonged to his forces who kept the women. Now, this is extraordinary evidence and could lead one to say, well, we'll never find that again. We'll never have another general who is absolutely brilliantly stupid enough to write down in a diary the women that are kept in a house of prostitution. But that's evidence of his knowledge, but his real knowledge was that he knowingly wanted to persecute the Bosnian Muslims and the Bosnian Croats, and that the persecution would be carried out by various illegal means. We didn't know that he did know the specific name of a woman, and that need not have even have been evidence. That just shows that when evidence that specifically incriminates, it reinforces his intent to have persecuted on a much larger scale. But what I want to highlight here is that 25 years ago, we were so concerned about that individual errant soldier who committed sexual violence, but certainly was a one-offer, you know, kind of on a frolic and a detour. It really had nothing to do with the war and a lot to do with the mental state of that one perpetrator. We have now moved beyond all the falsehoods of that discussion. We understand that sexual violence actually is a manner to enact a war, a manner to carry out a war, a manner to carry out detention. And we carry it out, in particular within the Yugoslav situation, in detention forms against both men and against women, against boys and against girls, and against the community. I think when you look at the Special Court for Sierra Leone, some of the jurisprudence that also merits much more dissection and then diffusion and common knowledge is that we realize that Charles Taylor, who also was a leader, remember we're talking about a president of a third country who was convicted for aiding and abetting non-state forces in a different country of sexual violence. Among the convictions is terrorization of the civilian population, which is a war crime. How do you terrorize the civilian population? Via sexual violence. Sexual violence of men and women, boys and girls. I think many of you would agree that if you understood that members of your family or yourself were to be sexually violated, you would almost self-deport. You would be terrorized. It's an effective way, in quotes, to ethnically cleanse. And it is something that a leader, a supreme leader, and a leader of a different country can be guilty of. I bring this out to say that between Plavšić, Krajisnik, Mladić, Taylor, Kabanda in Rwanda unfortunately pleaded guilty to genocide, but without sexual violence, although we have sexual violence from his chief of staff, that higher-ups are responsible, are completely responsible for sexual violence as proven by the different prosecutions that have been undertaken at the ad hoc tribunals and the hybrid tribunals. The other thing that we should note is that prosecution has allowed us not only to look forward via the Rome Statute, which talks about crimes that will be committed in the future or committed now, it's allowed us to look backwards. And beyond looking backward at the comfort women, we've been able to look backward at Cambodia. The Cambodia genocide, we basically look at as a type of killing fields, killing machine. But because now sexual violence is part of our conversation of crimes and of human rights, when we look back at Cambodia and look clearly at facts that lead to evidence, we understand that there was rampant tens of thousands of forced marriage. And the forced marriage entailed the forced union of males and females who the state made copulate, which is a code word for rape each other, so that they could produce children for the new regime. By understanding that this was a state-enforced policy of sexual violence against males and females, we understand the real nature, the policy and implementation force that sexual violence can have in terms of genocide and crimes against humanity. Now, what I would like also to juxtapose this implementation of sexual violence and our ability now to recognize it is that we have to even go further in understanding the perversive nature of sexual violence in our society. It's well and good to say it happens during genocide. We can certainly look at the Rohingya now. But we can also say that the sexual violence that takes place in the non-armed conflict situations, and I don't mean the sexual gender violence that happens when a woman in Brooklyn is raped. It's treacherous, it's horrible. I'm talking about systematic sexual violence such as perpetrated by a church, such as perpetrated by universities, such as perpetrated sometimes by institutions where persons who do not have economic rights and who do not have rights to health are housed for all of their life. When we start to join that together and understand that that could also be looked upon as crimes against humanity, non-armed conflict sexual violence that enters into a system that has a purpose, and usually that purpose is about control. That purpose is about how do we persecute with a little p, but that still might be criminal. This is where our real discussion should be taking us in the future in terms of international crimes. I would like to say, among the most overlooked crimes today is the slave trading that we euphemistically call trafficking of girls and women. It is a crime that is often based upon not just sexual exploitation, but threats of sexual acts and sexual acts themselves. But when we look at sexual violence as a mechanism to produce money, a mechanism to have what's an economy on black, we should not be surprised and shocked. We should see how sexual violence has worked at war, why Milotic could be involved in sexual violence, Charles Taylor can be involved in sexual violence, and then not be surprised when that makes up part of our black market, when that makes up part of the areas that we still are taboo in terms of speaking about and non-armed conflict. I would like to give this one example of sexual violence. And it stands clearly in front of our face, or it certainly did historically, although it has not allowed us to actually articulate it. And it's the sexual violence that occurs during apartheid. Now we know apartheid is a crime against humanity. In the United States, we called our apartheid Jim Crow. And we know that among the means and mechanisms that Jim Crow was enforced was the sexual violence against black women, and particularly black women who were maids and were isolated and worked in individual houses and stayed in a room in the back near the kitchen and were subjected to sexual violence. And that we know that during the lynchings, over 3,000 African American males were lynched within a 100-year period. And during that lynching, what often occurred was cutting off of their genitalia. And one would say, well, did this really happen? Well, unfortunately, I can show pictures. I can show artists who've done renditions of that. But the point is that apartheid maintained control, enforced persecution via sexual violence. Unfortunately, these were everyday occurrences. We have everyday occurrences of sexual violence that are happening right now. If we are looking for the missing piece, I think we have to understand what is peace. And I think the Special Representative has said it's more, we need a peace of mind, a peace of presence. Peace now should be defined not by the absence of armed conflict. We are too tied to UN Security Council resolutions or even the UN Charter, where we're trying to devise, was it a legitimate use of force or not? Was peace, the breach, broken? Was it restored? Peace should be defined by the absence of human rights violations, by the absence of armed conflict, by the absence of sexual violence. Now, maybe I have a bit more foresight, but I think that might be our conversations in the coming years. And what I would really like to say is that if prosecution in any way can work to prevent and to maintain the peace, I think that that's where we should be putting our effort. Prevention of sexual violence is one way of securing peace among us. Although, when there is the rampant sexual violence that occurs today, we see it happen in Myanmar, we see it happening in Bangladesh, we know that it's still happening in DRC. We cannot hide behind concepts of crimes of aggression, use of force, because unfortunately, since Nuremberg and Tokyo, we've removed probably the crime that should have been the most meaningful that we could talk about today, and that's crimes against the peace. And I'd like to end there. Thank you.
Thank you very much for very thorough and thought-provoking and good presentations. I have a few questions for the panel, and then I think we'll open up for questions from the audience. So if I may, I will address some questions to you, and I would like to start with Ms. Patten. And I'm thinking we're at the timing of this conference is, we're at the end of the work of the ICTY. We have a lot of experience with international criminal prosecution now of these crimes. And I would be interested to hear from where you're sitting in your position now, how do you see, what is your most sort of optimistic view of how this contributes to peace building? What is your more negative sort of feeling towards it, or negative thoughts about how it contributes at this point of reflection, if you like, in time? Big question. The others in the panel may jump in, but I thought I'd address that question to you.
Right, the success of ICTY, but also ICTR, both their success and their failures have been provided the foundation for the discussion for the ICC, for example. And I think to look at the failures or successes of ICTY in isolation, I don't think it's very legitimate. I think we have to look at the establishment of the ICTY in its context at the time. What did resolution, I think 757 of the Security Council, what were the expectations of the ICTY? And if you look at the resolution that established ICTR, it went beyond, because, for example, for ICTR, there was also the question of building societies, about reintegrating societies. I think there was one thing which over and above ICTY that we saw in the terms of reference were completely different. And how do you measure success in achieving peace, in deterring future atrocities? I think personally, I recognize the huge contribution of the ICTY, just like I recognize today the ICC and the power of the ICC as a permanent fixture in the international criminal justice system, but with the constraints that we all know, jurisdiction, mandate, funding. So for me, I don't think that we have the actual recipe to measure. I think the ICTY has contributed significantly in terms of bringing sexual violence out of the shadows, in terms of the number of cases of sexual violence that it has actually heard, the number of prosecutions and convictions, and also what it has done in terms of directing its database to national authorities, the impact that it has had in terms of building the capacity of the national jurisdiction. And I think there are many lessons, very positive lessons, to be drawn from the ICTY.
Anyone want to add something, or? Yeah, Christine?
Just to add one point. I think that Patty summed it up in some ways when she said the looking backward and looking forward. When the ICTY was created, there was this particular provision that its statute could only be on what was existing law at the time. But what it showed by putting that down in a contemporary context of so-called new wars, it allowed the prosecution and the judges to push forward and to see where that jurisprudence could move, to start crafting definitions. As definitions got crafted, commentators came in, pointed out what was good, what was bad. So again, what you just said, it sustained that conversation, and it has allowed it to continue into the ICC, and most importantly, as you just said, into the domestication of international criminal law. I mean, that has to be the most important, lasting message.
I just noticed one thing you said when you gave your presentation, Ms. Patten, that you said that wars are not just fought, they are told. So I was thinking these courts are really spaces for telling in ways that we haven't had before. Patricia, did you?
I want to say, I guess, ironically, that we know at the peace process in Dayton, Karadzic was there, who would later on be convicted. And within Mladic's judgment, you will realize that among the reasons that they knew that he knew of crimes being committed is that he would advise the assembly what to say at the peace process. So, with the interaction of perpetrators. But I do think that one of our main challenges today is bringing women to the table to talk about peace, because we're still being sequestered as if peace were a militarized issue. And our legitimacy of being at the table and not discussing peace, but negotiating peace and really establishing peace is still questioned. Who do we represent is often.
And I think I just want to add from what Christine said about CEDAW bringing the human rights maybe from the back door to a certain extent. I mean, like in 2010 when I initiated GR30, and the title was really, the focus was on conflict prevention, but also the role of women in conflict and post-conflict situations. And what we did was to use CEDAW as a legally binding instrument to monitor implementation of Resolution 1325 and all subsequent resolutions of the Council on Women, Peace and Security, and getting states parties, 189 of them, to provide information on implementation of the WPS agenda. And I see this happening. I mean, like we have, for example, revisited our reporting guidelines, and we have targets and indicators and very specific reporting guidelines to ensure that we get this information. I mean, last year I briefed the Security Council on the 5th of December on that synergy between CEDAW and Security Council resolution on women, peace and security, and that was most welcome.
Thank you. Ms. Diop, I have a question for you too. One of the findings that we have made at PRIO in the research that has been done on sexual violence in armed conflict, building up this global database, is that, not so surprising, but it's now documented that when conflicts end, sexual violence does not necessarily end. And what the people who worked on this database did was they gathered data in the 5-year period after the conflict ended and found that sexual violence doesn't necessarily go down, and the actors involved are not necessarily non-state actors, so it's state actors. So, Ms. Diop, in your work, or how do you comment on that, and what would be the role, in a way, of criminal prosecution? Can it mitigate this somehow, or what are your thoughts about this?
Yeah, I think your findings are reality on the ground, and I think what you said is the continuity of the war, of the conflict in the mindset of the people. And it's also the absence of justice that we could see on the ground. And that is where I think we need to look at the domestication, because we could, work at the international level, the ICC. We have ad hoc tribunals like the Rwanda and others. But in the same time, I think we need to look at, for example, the case of Sierra Leone, the case of Liberia, the case of, what come after. And we tend to leave the house after the elections and not put in place the real structure that can go down. I mean, one of the cases that we can look at, for example, is the gacaca for example, because you need to have a larger discussion on truth and reconciliation, but also a larger discussion on the justice and put in place. In our report on South Sudan, we really recommend that we reform the justice system that can address these issues of, sexual violence. Recently, in Banjul, because we have the African Court, the African Commission on Human and People's Rights, we invited CEDAW in terms of looking on the guidelines for reporting with the Special Rapporteur on violence against women in Africa to work both in terms of the putting in place guidelines for reporting by member state on sexual violence, but also by the civil society as well. So I think it's one hand is the international or regional, but we need also to look into the domestication of the laws that we adopt. Protocol, the African Charter is beautiful in terms of the rights of people, not implemented. When you look at the Maputo Protocol, as I said from the beginning, it's also one of the very progressive instruments in Africa. But when it comes to implementation, as I said previously, it's the key issues. So we need to make sure that the new laws that Liberia, for example, as a case, and it was pushed by the leadership, but also by the women, to have that the law put in place, but also how do you implement it by bringing the prosecute those that continue to violate and to sexually abuse, continue to abuse the people. So I think going deep down at the national level is very key. So we don't just leave it to the ICC.
I can just add in terms of the joint communique that my office has signed with a number of countries, and some of them I'm revisiting because they are quite old. Legal reform is one major component. So we are also supporting capacity of these countries in accompanying them in their legislative reform process, looking, for example, at victim and witness protection. For example, with DRC, that's something concrete that I'm working on, the victim and witness protection law, access to justice, and also training of investigators, prosecutors, law enforcement authorities, military, and the justice sector. And I would just really like to reiterate what Bineta has said, that ending impunity is not cannot be the preserve of one single institution. And one of the key strategic goals is really to promote international criminal justice system, the ICC, as a role model for national institutions to address sexual violence cases.
Thank you. Christine Chinkin, I have a question for you too. You've just written a very big book with Mary Kaldor about new wars and international law. And again, it seems that we're at a time, having read the book, we're at almost all of it. But it seems that, again, we're at a time where human rights, women's rights are contested in ways that were not so long ago. So how do you see how do you see the future? Where are we in 5 years? How is this going to evolve as you see it? And what does it mean for addressing conflict-related sexual violence?
What the book is trying to demonstrate is how so many different facets of what Mary Kaldor calls new wars, how coming together in ways that challenge the existing legal structures to address them. So the regulatory frameworks that have evolved post-1945 and the sort of establishment of the social order at that point is fragmenting. And we wrote the book before the latest administration in the White House, which I think it came out exactly at that moment. And I said, oh my goodness, the book is now out of date. Mary said, no, it's ever more important because of the issues that it addresses. And what we really argue for there is a model of security that is putting human security in the broadest sense. Human rights is one component, but other components include issues such as being raised this morning about what is understood by not just peace, but the security bit of Chapter 7 of the United Nations Charter and the Security Council's mandate. And that security has to be seen as well, not just at this international level, but at the domestic level. And that mechanisms at both the international, I think we're really moving from an international law that may or may not get incorporated domestically into perhaps call it a hybrid legal system that starts from a point of so-called human security, broadly understood, but very clearly gendered. What is it that makes women's lives insecure, and how must those be addressed? And to do some hard thinking around, well, how can that be evolved in various ways? Our comment was, we'll be told we're being utopian, we're being idealistic, but our response to that is the militaristic model is not working. The contemporary peace process model is not working. So that we certainly are not capable of doing, the really deep thinking. It needs sustained conversation among a lot of people. But I think we need to start from those assumptions.
Thank you. It's a big...
It's like an example.
big thing to take in. Did you want to comment?
I want to comment because, Christine, we had discussions on New War before, and I'm happy to know that this book has come out. I'll have to run to read it. But I think that you're completely right in this war, as militarized thinkers have thought about it, has even gone beyond the definition of what is war under the Geneva Conventions.
Yeah.
I mean, terrorism. So we are in a new world, whether we want to be there or not. This is where we are. And I would just add that it's a question of gender-based, gender expression, gender identity, but one of the things that we carry with us no matter where we go is our sense of sexual integrity or our insecurity about our sexual integrity, and that is following us into these new domains of terrorism or new wars. We just wanted to add that.
And crimes against humanity may well be the best vehicle for really pursuing into that.
Mm-hmm.
But, did you want to comment? Yeah.
No, I just think that the war that we have seen in Africa before, the civil war, and the recent war, that conflict, violence, conflict in elections, and so on. I think Africa will move away out of those, because we cannot continue to finance our conflict in that way. But we have because we have a bigger picture, and the new war is, as terrorists, we have seen Al-Shabaab, Boko Haram, all of this, is not just about our continent, it's a global. It's going to affect everybody. So instead of just dealing with the Central African Republic, where we, or dealing with the internal, that we have seen civil war of DRC, I mean, we have just to deal with those issues, which is a power sharing, which about, the resources that we have on the ground, and so on and so forth. So those things we need to really, really settle those conflicts and attack and put most of our resources in the bigger picture. Because when we went to Nigeria and we saw what Boko Haram is doing, when I went to Somalia, I mean, it's so sophisticated. the war that we have in front of us, that if we want to dismantle, it's about new technology, it's about so many other things. It's, abducting the girls for millions of girls, suicide bombers of young. So how they recruit the young people in the university, even people that are educated. So it's a bigger picture, the new war that we saw on the ground, that the other war, I think we need really to deal with it. And the issues of violence against women, it's bigger now as we see it, because now the abduction of young girls, in thousands and hundreds, it's a bigger picture that, I'm not saying that the usual rape process or system that was put in place is not, we should not undermine it, but in the meantime, the rape of the young girls and young boys. And young boys, I have seen young boys, first in my life, a big number of young boys that have been raped, that I think that these are the new wars and the consequences and the impact on the people that we need to, all of us together address it, because what happened there will impact here. So that's the reality. We have the migrant, we need to, the elephant in the room, migration is there, and we need to see how we tackle it. We see slavery, we have trafficking, and a big trafficking. We have just seen what CNN did on the Libya, what we saw, trafficking of human beings. Those are happening right now while we are talking, in numbers and great numbers. So we need together to work on this new war. That's the reality.
And also, I think, just to stretch the discussion, I mean, I recall I had this experience when I was in Afghanistan, supporting them on the review of their report, and raising questions about women in peace negotiations. And then the Minister of Human Rights blurted it out, and he said, no, that the Taliban has imposed a condition. It's going to be women or peace. As much as, and I had even a recommendation to the UK government. I said London round of negotiations excluded women, and then I got the answer from the Afghan themselves, and they said, what do you want us to do? And today we are confronted with a similar challenge that, for example, the ICC is facing. It's about prosecution, peace versus prosecution. I mean, there's Myanmar right on our plate, and the question is, will a Security Council resolution jeopardize the chances of Bangladesh and Myanmar reaching a comprehensive bilateral solution, long-term durable solution? And similarly, I think there's and I think maybe Priyo could do some more work and research on how to balance these competing goals, whether justice and peace are contradictory forces, or if properly pursued, they should be promoting and sustaining one another. Because often we see that when the prosecutor of the ICC, for example, conducts an investigation during or in the immediate aftermath of a conflict, she's likely to face claims that her actions are an actual or potential obstacle to peace, just like we face it in the Security Council. So in attempting to reconcile these competing public policy goals in such situations, I think there's a lot of work to be done to really support or bring out the point that prosecution by the ICC remains one of the few credible threats faced by leaders who commit atrocities, that justice and peace can be mutually reinforcing, and that impunity should never be an option in these dynamics, because that's a huge. that's a usual. It is a real challenge to the ICC. As much as we hear many criticism leveled against the ICC, but I think we also have to see under what constraint they are working.
Thank you. Patricia, last very short question. You've worked at the ICTY on sexual violence crimes. Now you're working with the ICC on the same kinds of crimes. What's going to be different in the ICC? What has been learned from the work in the ICTY, and what needs to be differently handled in the ICC as you see it?
Well, I think a lot has been learned. I think we've moved from looking at sexual violence as types of incidents that only pertain to females, incidents that were just related to the war, but now we're looking at sexual violence in a much more complete way. We're looking, first of all, males and females, boys and girls. We're looking at sexual violence as part of the system of the war or the system of the crimes against humanity, that there's a policy reason underneath why this sexual violence is occurring, and often when one looks from the perpetrator's point of view, that it does have a function, and we keep running in and finding that function. We're starting to understand how to genderize and sexualize, whether it be torture, persecution, whether even forms of killing can be sexualized killings, and understanding that within a genocide, that the sexual violence or using someone's gendered identity, their gender expression, or stopping births of children or breeding children, that the sexual violence gives us a much more completed view of the atrocity that's occurring. So I think that's been among the things that the past 25 years and frankly discussions like this have brought us to. One of the things I do want to state is that for instance, that now you have investigators and lawyers who really are at levels 6, 7, and 8, whereas before you'd want to sit them down and be nice to them, maybe bring some coffee, we're going to talk about sexual violence, don't worry, it won't hurt, you know. Now, they're really at level 7 and 8, okay, how do we make sure the military analyst is in on this conversation? How do we make sure that we're looking at digital, you know, evidence on this conversation? So I think, thank goodness, it is lessons learned, and we're still going to make mistakes, but we just hope that they're different mistakes than we've made in the past.
Thank you. I think we will open up for questions from the floor, but before I would like to invite our final speaker to join the panel. We're in the middle of a conversation, so I think we will continue the conversation and give you the word towards the end, but I just want to introduce you very briefly. It's Lord Ahmad of Wimbledon, UK Prime Minister, Special Representative on Preventing Sexual Violence in Conflict, and you will give your address towards the end of the seminar, but would you like to join the conversation by being on the panel here? Then I think that what we will do is we will take a couple of questions and you take notes, and please be very brief and say who you are and which organization you represent. Yes. So Julia, are you?
Good morning. It's still morning, yeah. I'm Hrvoje Maroši, the Croatian ambassador to Norway. I want first of all to thank you for being here with us, and also to thank you for the fantastic work you are doing at preventing and fighting these appalling crimes. And I want to thank you as ambassador of Croatia, which supports fully the prosecution of such crimes and the various initiatives like PSVI, but also as a father of 2 little women and a brother of 2 sisters. So I'm very concerned about what are the risks for women in today's world. I also want to say that I fully subscribe to what has been said, that sexual crimes are worse than bullets because they aim at soul and dignity of persons and communities rather than just the bodies. I have 2 questions. One concerns the fact that migrations as a phenomenon which is generated by conflict also are a situation of high exposure to violence. So whether there is, my question is whether there is any specific monitoring of sexual violence in all its forms within the migratory flows. And the second thing is, anybody can reply. Second question is, what is the importance of national prosecution of sex crimes? I mean, international prosecution is very important because it extracts perhaps partly the prosecution and depoliticize the prosecution of sexual crimes, which is good. But then again, it's extremely important also to build, to enforce prosecution also on national level. So these are my two questions. Thank you.
Thank you. I think we'll take a couple of more before you answer. Yes, please at the back. Or, yeah, Julie, you have control.
Thank you very much. I'm Silvia Gurola from Health and Human Rights Info. And I wanted to bring to your attention something that also brought my attention now that I was in Zambia and communicating with two networks of lawyers in the region, WILDAF and another organization, I'm forgetting right now the name. But they both agreed that they were not aware on the fact that they are not using science with regards to the reaction of the survivor when they are facing trauma, when they are facing rape. And it is about 60 to 70% of them that freeze during the act. And that has given the opportunity to unsensitized courts, lawyers, to say that that was not a rape, because there is a lot to understand in terms of consensus. So I guess that even us, many of those who are working and advocating against rape in this very many contexts beyond war, is that ourselves are not taking advantage of that tool, and therefore my call to make it happen at all levels of criminal courts for them to understand what happens to the victim.
Thank you. That was more of a comment, I guess. Let's take three more, and then I think we need to... The woman in the back was first, I think. Then you, and then we have a round of responses.
Thank you very much, and congratulations to the panelists. I'm Dr. Thelma Awori. I have accompanied Bineta Diop here, the special envoy. I'd like to address my question to USG Patten on the issue of the impunity of UN soldiers who commit crimes against those people that they are supposed to be protecting. I don't know whether member states have accepted the option of doing a DNA test for every peacekeeper so that we're able to trace who is the perpetuator of the crime, and so that they can pay. Also, how is the program now for assistance to victims? Because the last time I did an evaluation in DRC, the assistance to victims was just totally undeveloped, and that needs to be addressed. The second thing that I would ask you to please put on your agenda is that this issue of the reconstruction of women's bodies after rape as part of the reconstruction and rehabilitation program should be funded in a major way, because our experience from ISIS Wiki of moving into Liberia and in Uganda to do the reconstruction of women's bodies means that there is a lot of money to be used to bring gynecologists and psychiatrists to do these operations, and it has to be a mobile clinic. It can't be just stationed in one place. You have to go to where the victims are, and that requires a lot of money, thanks to the Germans who funded the first amount of work, but we need money for that kind of work. Thank you very much.
Here, yeah, there, and the gentleman there, and then we draw the line. So, yeah.
Hello, and thank you very much for this wonderful panel. I'm with the Georgetown Institute for Women, Peace and Security, and I have a question especially for you, Patricia Sellers. There is this divide and complementarity between international criminal prosecution and national prosecution, and even though international criminal prosecution will focus on both sides of the conflict, there is an issue with national prosecution and especially what we call the winner's victory, the winner's justice. I saw this issue in Côte d'Ivoire, notably, where the claim against the new government of Alassane Ouattara was that he only focused, or the prosecutions only focused on the atrocities committed by Laurent Gbagbo and his side, but not on the side of Force Nouvelle. And so how do you address that issue, and what would be recommendations to deal with that?
Okay, then the last question. Yeah, the gentleman here to the left.
Hi, my name is Leon Waye. I'm a former ICTR and MICT counsel and a PhD candidate at the University of St. Andrews. I want to say thank you to the panel for a wonderful presentation. It was very informative. Now, my question relates to the justice versus reparations question on peace building in a particular context. Now, the particular context is, like, for example, in Nigeria, in the ECOWAS court, the government has recently agreed to pay the victims of the conflict 88 billion naira, which works out to be about $250 million. Now, this is a source of tension in the government that successive governments haven't acknowledged the crimes that were committed, including sexual violence, because there was abhorrent sexual violence that was committed during the civil conflict. Now, my question is, now, the fact that they've agreed to pay this compensation, does this obviate the need for justice? And also, like the example you gave, how can you, given the evidential issues, because this conflict happened like 47 years ago, how can you begin to assess victims of sexual violence? I mean, given the fact that for many years no one has acknowledged criminal responsibility. So that's my question.
Sorry, which conflict?
The Biafran Civil War.
Sorry,
yes.
I didn't catch.
Sorry.
Okay, thank you.
Thank you. We have about 3 minutes to respond to this. So please be brief. So if you can think in terms of bullet point responses, I think that's the way to go, but please feel free. I don't know if anyone wants to take the word first.
Okay, I'll start and I'll try and be brief. I mean, to the question, in responding to the ambassador of Croatia on the question of migration, I mean, I just want to say, like, from the perspective of my mandate, we have Resolution 2331 of the Security Council in 2016 that brings the nexus between trafficking, terrorism, sexual violence, and we have redefined conflict-related sexual violence to include migration, to include trafficking, and now for the extremely vulnerable population in Cox's Bazar that have crossed the border from Myanmar, we are addressing that dimension. In terms of the importance of national prosecution, I fully agree with you that I think it is a good thing that after many years of supporting the ICC, a number of ICC stakeholders, for example, have shifted their attention and resources to complementarity, because we always have to remember the principle of complementarity, and that the ICC was devised to be a court of last resort. And it is, for me personally, a good thing that supporting national jurisdiction remains of utmost importance, and we must always remain focused and committed to building up national jurisdiction. Very briefly on the question on SCA, I mean, like I confess it's a very difficult question for me, because I came in when the Secretary General had already come up with his compact on SCA, and it's the dichotomy between SCA and CRSV is very fine. It's very disturbing personally for me, but it's like a fait accompli, and I have to engage with DPKO because they have been very resistant to every suggestion of my office that we have an issue with SCA. But I'm trying to work very closely with the newly appointed victim rights advocate who was appointed in September, in addressing sexual exploitation and abuse and ensuring that it's dealt with on a case-to-case basis. And I just fully agree with you on the reconstruction, the importance of the psychosocial support, but dealing with women that have endured very, very severe trauma. And I'm glad that you mentioned the Yazidi women, because I actually met them, and I really commend the Germans for their special quota project in terms of the women that they have brought in Germany, but also for having, for being the one of the few countries addressing trauma, having set up an institute of traumatology also in Iraq, in supporting the women. Thank you.
Thank you. Any Bineta? Yeah.
On the issue of migration, I just wanted to add that now that the AU is involved on trying to bring the two leaders in terms of the migrant in Libya, the specific case of Libya, where lot of reports have come that there was forced prostitution, sex slaves. Women have been in the middle in a large number, as we understood. It's not just the CNN, but also the many NGOs before the CNN have talked about the situation of in the Libya case. So the accountability of the two leaders that are in Libya, but also of the international and the African leaders, international community, to address these issues. So I think it's just the starting point. IOM and the Red Cross and others are helping to look into the matter. But in my own mandate, being within the African Union, is to help the Department of Peace and Security as well to address the issue when they're discussing, but helping also civil society and NGOs to document and look into the case like you did, Pramila, on the Guinea case, where we all, I remember you were part of the mission, and we went as NGOs and women's group to document some of those cases, and it needs to be done. The zero tolerance policy, I'm very glad that Thelma mentioned it, but Lord Ahmad is here. We started, my role being as my mandate to make sure that it happened. So one of the cases I tested, as I said, was Senegal, with the support of UK government, to make sure that we train the pre-deployment training. We train them before we deploy them, and we continue the training when they are on board, and make them put in place the accountability process as well. And I think, Lord Ahmad, we need to look at the Sahel issue, not just countries that are deploying, but right now there is a force that will be put in place by UN, AU, and others, and the Sahel is a test. We need to look at that new case of peace, security in Africa. It's a model that where we see that countries that are, because it's the RECs usually that are taking care of the peace and security, the regional economic community, IGAD, and so on. But this is a new model of dealing with peace and security. And I think we need to study it. It's very new. Is it going to work? We think yes, but we need more. And the pre-deployment training of the forces in the Sahel will be a testing case. Yeah, thank you.
Thank you. Would the other speakers like to add something briefly?
Very briefly. In terms of national prosecution, let me put two of the interveners' questions together. Of course, not only do we have to have national prosecution, but it has to be a continuing effort. It can't be just a show trial at the national level, because the national level should be performing just the regular rule of law for every nation, which also means that state legislatures have to fund it. I mean, this has to be something that is valuable for taxes to go to. And if I combine that question as well under state, within state courts or national courts, that often you have your own version of victor's justice, well, we see that that's where the rule of law is kind of being pushed back by the political project of any state that wants to fortify its own government. And while that is not the equivalent of really giving justice to the victims of both sides, we understand that that's probably one of the political wills that will be the most difficult to overcome. So therefore, let's think of the system as being an ecosystem that's much larger. As we've stated before, the ICC might take very few cases, but it will take some cases. But there are other means of getting to the opposite of victor's justice, and neighboring national courts or national courts anywhere around the world should start exercising universal jurisdiction. And I think that we're always underplaying the ability for states to actually exercise universal jurisdiction along with states who might be enacting a type of national processes. And I think that when we think a bit more complete in that sphere of international prosecutions and various types of national prosecutions, we might be able to lessen the impunity. And I just want to say one word in terms of the reparations or trials with the Biafra situation. And I don't know why we get caught again in an either or, that we can't have both. And I think that the trial with Habre certainly shows that we can go back 20 years and have a prosecution. And the state can still give reparations, and there can be support to NGO groups or those who would want to bring forward prosecutions. And I think that we must not get into the situation that certain governments want to say, well, if I've paid reparations, or if the statute of limitation for reparations is over, such as with the comfort women, then that means that my hands are clean, I have nothing to do. Because that feeling of injustice will just fester and will grow and will explode.
Thank you. Christine.
Yeah, very quickly indeed. I think going back to the national jurisdiction issue, Patty just mentioned universal jurisdiction. Now, every country is in fact a party to the Geneva Conventions. And under the Geneva Conventions, there is an obligation to domesticate grave breaches of the Geneva Conventions, to prosecute, and to exercise universal jurisdiction. I mean, I think one of the problems, well, not a problem, but one of the consequences of creating the International Criminal Court is that the basic provisions of the Geneva Conventions have just got forgotten, and they still exist. But, and I think again to link probably with the comment rather than with a question, we do also have to remember that national trials are often very deficient, particularly when it comes to crime trials of sexual violence. And in my own country, I think the conviction rate of those cases that reach courts for rape is something around 10%. And so we need to look very seriously at both the international jurisprudence, what national courts can learn from that, and continue working on reform of criminal law and process, and link all of this with, for example, the CEDAW general recommendation on access to equality of justice for women. I mean, that seems to be absolutely core. And so general recommendation 30 should be looked at with general 33. 33. One word, I agree with what Patty's just said on reparations. I think we also need to think about a broader concept of reparations. I mean, in one sense, and you talked very clearly about how sexual violence is integral to the concept of persecution, which means, and terror, which means that very broad section of the population are in fact victims. Right. And so reparations such as memorialization in public sort of aspects, the apology that the comfort women are still seeking as a real apology. So reparations in that broader sense, I think that the power of those, particularly after nearly half a century, can still be very important.
Thank you. I think we will just then give the word to our last speaker, who is, as I said already, Lord Ahmad, who is the UK Prime Minister's Special Representative on Preventing Sexual Violence in Conflict, the PSVI initiative. And we're very happy that you're here. You flew in this morning because you had to be in Parliament, I think, this morning. We'll go a little bit over time, but we're very happy to hear your address. So please take the floor.
Well, thank you very much for that introduction. I'm delighted to be here. I suppose when you're summing up what's gone on, and you've only been there for part of the discussions, it's a bit of a challenge, but nevertheless, I think 3 observations, if I may. First, on arriving late, I think the challenge of a politician is always that you have varying priorities, but this was certainly one that is right up there, and I'll come on to talk in more substance. But I think you're forever juggling, and in this regard, I think both Pramila and I feel that we're on a kind of European roadshow on this subject, which underlines perhaps the international priority. Secondly, as a politician, if I may also observe, you get questions from the floor. You've got such distinguished panelists next to you, and you have to observe the code of conduct for a politician, which is probably the most difficult one, to stay silent and listen, because I think that's one of the most valuable learnings I have had in my time in government. The third element on a personal reflection, often when I arrive in an audience, I can define myself as a minority, but that minority is often by ethnicity. But I'm delighted to be a minority on the panel and indeed this room because of my gender. And I think that underlines the importance of ensuring that women's voices are heard at the highest level. So in saying all that, it's my real pleasure to be with you here this morning and indeed join such a distinguished panel. And from the discussions I heard both during the Q&A when I was listening from the audience and indeed joining just now, that it has been one which is thought-provoking. And I'd also say that this important issue is also one which I would define as being very much work in progress. Madam Diop mentioned the particular issue on training of soldiers, and I observed some of the questions. I think in that regard we are making steps forward, but it is very challenging, and I'll be very candid that when you look at some of the challenges of deploying troops, you want those peacekeepers to go in. They're also peace builders. But in doing so, it is undeniably one of the biggest challenges. Then the very people that have gone in to bring about peace then commit such crimes. So that challenge is one of training, it's of ensuring consistency of training, but also one of accountability. The challenge within an international perspective, and it's something the UK along with others face up to, there are many, as the UK does, fund peace building and peacekeeping within the context of the UN. But quite often the people who are the financiers when it comes to international country aren't the troop contributing countries. So there's a gap, to be totally blunt, that needs to be filled with those who are providing the troops and those who are providing the finance for those peacekeeping operations. We ourselves have taken a step forward. We are certainly now contributing more widely in terms of our troops. And in that regard, I was delighted most recently. I heard very carefully again, Patricia, you mentioned when I walked in, you were talking about how conflict is now viewed, but also when it comes to conflict within militarizing a conflict, that often women's voices are not heard. But most recently, I think we should be encouraged by the fact that when the Vancouver event took place, again, the emphasis was one of gender equality. It was of ensuring gender representation within the armed forces. But even, I have to be honest, by the end of this year, we aim to hit a target of 15%. But that target is still a low threshold to ensure that the people that are keeping the peace are representative of the populations in which they're keeping the peace means we have to have a higher threshold of women who are involved. And those who've known me in speaking on this subject, I totally concur with the views of the panel that we must look at conflict in a much wider concept. The wider concept is not just of conflicts or wars between two countries or across a region. The war is much deeper. And as a minister within the UK government, as well as being the Special Representative Minister for Human Rights, I also have the responsibility for looking at issues of counterterrorism and violent extremism in an international perspective. And that, to me, has certainly given me a focus that if we are looking at some of the challenges, and Madam Diop talked of the Boko Harams of this world, the Daesh's of this world, the Al-Qaeda's who commit the most heinous sexual crimes. If we look at what happened in Syria and Iraq, the throwing off of people who were gay off the top of buildings, women and young boys who were raped as part of that conflict, that was in the context of preventing violent extremism and not perhaps the traditional way of how we view conflict. So we do need to look at this in a much wider perspective. But today, I would like to set out the UK's views on issues of impunity, transitional justice, and women's participation in peace building, why they all matter to preventing sexual violence, and why a collaborative approach is essential. I know these are views shared by the panel. In particular, I know they're shared by the Special Representative of the Secretary-General, Pramila Patten. We share these views very strongly. And as the British Prime Minister's Special Envoy on preventing sexual violence in conflict, let me be quite clear, we also see the absolute acute need, it came up in the questions just now, for perpetrators to be brought to justice. From a UK's perspective, this issue that Christine mentioned also of universal jurisdiction is one we absolutely subscribe to. It is important whether we're looking at conflict situations or indeed, as I alluded to, the situations that we saw unfolding in Syria and Iraq with the return of individuals, often young men, who went to fight these foreign wars for causes that unknown to them through a perversion of a religion and interpretation which influenced them. However, we've been very clear that anyone seeking to return to the UK who is a UK national will be brought to justice for any crimes they have committed elsewhere in the world. And I think that is a message that needs to be sent out consistently, because the international courts, the valuable purpose they serve, and we are very supportive, at the same time can only be supported if national governments, but particularly national justice systems, take their responsibility in this respect. To better tackle impunity, we also need the right tools. That is why we set out STORE by the International Protocol on Documentation and Investigation of Sexual Violence in Conflict. In March this year, the UK published the second edition, which has a greater focus on how to analyze evidence and establish patterns of violations. This has now, importantly, been translated into a new edition of 10 languages, which is nearly complete, and it will also ensure human rights defenders, lawyers, police, the military, and others in conflict-affected countries have the right tools and training to gather evidence to strengthen prosecution against perpetrators of sexual violence. And it is important that we spend time and focus in getting this element right, both in terms of cultural sensitivities, but also bringing this issue right to the fore as a priority. But there are other priorities as well. First of all, we must do more to prevent sexual violence happening in the first place. Secondly, we believe in the need to end stigma for survivors of sexual violence. Our End Stigma campaign shows our commitment from the UK to tackling it. And as many will know in this room, that we have already facilitated multiple in-country workshops, which are providing a survivor's perspective on how to support them and their families where it is most needed. How, ladies and gentlemen, can it be right that a victim who has survived the horrendous nature and vile abuse of sexual violence is then rejected? Rejected by society, rejected by their community, and rejected often by their own family. In the UK, we are looking forward to hosting an international meeting in 2019, 5 years on from when this first initiative from a UK perspective was launched, informed by the workshops I've just mentioned, events such as this, and much more. It will give us the chance to take stock of what has been achieved globally to date and to identify further collaborative opportunities. As my colleague in the House of Lords and co-founder of the PSVI, Lord Hague, has argued previously, we must end once and for all these abhorrent crimes. But what it does require is collaboration. It requires international action from all players across society. And therefore, again, in the questions we just heard, I totally agree and concur with the panel in the sense of bringing together the experience. One of the questions is, what are we learning? What are we doing? What are we building? I honestly believe that the conferences such as these and the conference we are aspiring towards in 2019 will allow us not just to reflect, but learn from the experiences. I was once asked, what is one legacy in any role you have? When I look at my responsibilities, one of the most powerful and moving elements of my role has been when I've sat down with victims, women, yes, but also men, who've talked through their experiences, who've talked through the heinous crime committed against them, their person, their body, their physical being. Yet their strength, their courage, has meant that they weren't just survivors. And that transition has become one of being an advocate. It's how many of those victims to survivors to advocates we can have on panels such as this in international fora, because it is only then that we will truly fulfilling our obligation of ensuring that sexual violence, for the crime it is, for the abhorrent crime it is getting the international focus it deserves. Turning, if I may, to justice, the UK also views accountability as an essential element of justice. Without this, as I've already said, the process of reconciliation cannot truly begin. That is why it's so important to put in place effective transitional justice policies, not just to deliver justice to victims, but also rebuild trust and repair fractured societies. And I heard that from the panel this morning. The conflict, the crime doesn't end, or we haven't resolved it once peace has broken out, and too often those tragic victims are forgotten. Pramila and I started our respective roles more or less at the same time in the summer, but I remember and recall our very first meeting in her office in New York, where she highlighted to me from her own experience the fact that so many countries do not even recognize such crimes. In some places, it's not unusual for cases of rape, as we've heard already this morning, to be resolved by so-called amicable settlements. What can be amicable if a person has gone through being raped, and in most cases, most certainly women have been raped, for them then to be told that that criminal who committed the crime against their person should be their husband? Who protects them? Maybe they'll go into that marriage in some hope, as remote as it may be, that something may work out of this. But what hope, what protection can be provided to that individual in such cases? And in fact, there are now 37 countries, I believe, where perpetrators are exempt from such prosecutions if they marry the victim. It's just unacceptable, yet it happens. That's the reality. Unlike other forms of violence that occur during conflict, sexual violence is notoriously underreported, underdocumented. Survivors of sexual violence face significant barriers, be it to accessing support, justice mechanisms, and post-conflict services. And if I may put it really bluntly, many of these victims do not even know what to do, where to go, who to trust. And yes, tragically, the most vulnerable of people, at their most vulnerable, when they have become victims of sexual crimes, through the stigma associated with sexual violence, are rejected. At the time they need their greatest support, they are rejected. That is the capacity building we need to focus on. So it's vital, ladies and gentlemen, to ensure that sexual violence and other such crimes are part of peace negotiations and addressed in peace agreements, such as was done, and I acknowledge that, in the Colombian Peace Accord, where Norway has played such a significant role. This is a key part of transitional justice for survivors, families, communities affected by sexual violence. But I'd go further, not just for communities, for countries and internationally. Until we start breaking this mold, and Pramila talked and others about the issue of the Taliban and the Afghanistan conflict. If we're going to bring about, and this is a challenge I face as a minister every day, you sit across a desk, a table, in a negotiating table with someone. We have to, and we all talk about our values, we talk about what we're proud of or what we want to bring to the table. That is the time we have to show greater courage and actually ensure these issues are brought to the fore. To achieve lasting peace, these specific issues relating to sexual and gender-based violence must be addressed. Any transitional justice must therefore ensure that survivors aren't put to one side and forgotten about. They have to be heart and center of the process, so their experiences are taken into account, their rights are protected, and they receive the right forms of care and redress. And that is why, as I articulated earlier, it is important that we bring those survivors and ultimately those who have shown great courage, as I've seen myself, become the strongest advocates of ensuring this happens. Ladies and gentlemen, in many cases, survivors are women, and we all know the benefits of involving women in peace processes. We know peace processes, the evidence is there, are more likely to succeed and more likely, importantly, to last if women are involved. Research indeed has shown that women are, when they are included in peace processes, there is a 35% increase in the probability of an agreement lasting at least 15 years. My government, all governments, we talk about let's build sustainable peace. Well, if you exclude a major part of the population, if you exclude women from peace building, frankly speaking, to drop the accent, we ain't getting it. We are not going to be able to deliver what we need to. So the focus must be not just about talking about it, but by ensuring it happens. But despite these facts, often when you're a government minister, often when you're an international panelist, a professor or any lawyer or any profession represented in this room and beyond, one of the things we're told, when you want to change something, bring the evidence. Well, the evidence is there. Yet still, we do not see the change that is required. The importance of women's role in building and sustaining peace, therefore, cannot be understated. That is why ensuring that women's rights are not just safeguarded, not just protected, but promoted and strengthened, so that they can take part in formal peace processes. And importantly, once peace is built, we all hope democracy prevails. They have to be part of the wider political decision-making, and these are all priorities for us from a UK perspective. They remain at the heart of our work. On women, peace and security, just this week, we held a conference on women in mediation at Wilton Park in the UK to bring together women, mediators and experts in the field to share their experiences and lessons learned. And I'm also delighted to let you know that we announced the creation of the Commonwealth Network of Women Mediators at that event, which will formally launch at the Commonwealth Summit and Heads of Government meeting in April 2018. As Minister for the Commonwealth in the UK government, this is a personal priority. And we are also, if I may say, very grateful to many here and others for the incredible support you have given us in the development of this network. I mentioned earlier the importance of collaboration between policymakers and practitioners and between countries is vital. Closer to home, we also believe it's important to take a whole-of-government approach. Both Norway and the UK have put gender equality at the forefront of our foreign policy. And I know in Norway, as in the UK, preventing and combating sexual violence is a cross-cutting priority in all peace and security efforts. Norway's 2015 National Action Plan on Women, Peace and Security is setting their agenda for ensuring systematic progress on this issue. And in January, the UK will be launching its 4th edition of our own National Action Plan. This 5-year strategy will set out how the UK government will integrate a gender perspective to help work and build security and stability overseas, protect the human rights of women and girls, and promote their meaningful participation in conflict prevention and resolution. The work will remain a priority for our government in the years ahead. Clear in terms of our appointment of this priority by the appointment of the FCO's first, the Foreign Office's first Special Envoy for Gender Equality. And earlier this year, we created the Foreign Office's Gender Equality Unit, and I'm delighted we're joined here by the head of that unit as well, Rosie Cave. We will continue to work across the whole of government to ensure that gender perspectives are also part, and this was a point which was made by several panelists. It's not just what you do internationally, it's what you do domestically as well. We want to ensure these gender perspectives, these gender priorities are woven into our domestic strategies as well as those which are international, because we have to help improve women's inclusion and access to justice at home as well as abroad. And I know when I've attended events within the UK, different community events, and I often say a great strength of our nation is its diversity. But within that, we need to ensure better integration. And better integration cannot be achieved if I'm there talking about the virtues and values of my country, and I look across the room, and it is a room full of men. We need to start tackling these issues head on and ensuring what we talk about on international platforms, what we seek and aspire to deliver internationally, is reflected at home as well. To have the greatest impact, like-minded states, individuals, communities must work together, sharing knowledge as we've done today, supporting each other through policy making. To conclude, if I may, ending impunity is central to all our aims on preventing sexual violence in conflict. However, as the title of this conference suggests, we do not believe it should be our only target. Instead, we favor an approach that tackles sexual violence from a variety of angles. This means unblocking access to justice, as we've heard, getting more women involved in political processes and conflict resolution, and if I may add, on the important issue of preventing violent extremism. Only then will we start developing effective prevention methods. We believe addressing the issue like this from multiple angles is the best way to achieve our aims and make that difference we all seek to make in the lives of survivors of these crimes. I would like to thank all of you for listening to me this morning and this afternoon. I think we've got fast heading into lunchtime. But in doing so, I also say to you, let us come together and ensure that we learn from each other on these important issues. I must admit, when I reflect in my role as a minister, and I listen to some incredible panelists as we have done today, and I know that experience also translates and transcends across this room, I'm inspired, and you know, yes, as I said at the beginning, as a politician, as a minister, you listen and you listen very carefully. And I always go away and not just reflect on what I've heard and what it means for me and government, for our government, but also underlining that these sentiments are not enough. We must also act. Through working together like this, governments and international organizations, community, faith groups, individuals, whatever profession you're in, interventions and policies are strengthened when they're properly targeted, sensitive to survivors' needs, putting survivors at the heart of those solutions, and most importantly, they are effective when we also ensure that women are part and parcel, heart and center of all solutions. We can look to Syria, Colombia, Iraq, Yemen, Burma, Libya, Sudan, the list goes on. These are just some of the conflicts where we know sexual violence takes place. Therefore, we ask the question, if not now, then when? If not us, then who? Let us therefore collectively pledge to say that if we can, and we shall, we will do all that is humanely possible to highlight through various forums, through our individual, collective, bilateral, and collaborative efforts to address and ultimately prevent sexual violence in conflict. Thank you.
Thank you very much, Lord Ahmad. That was an inspirational closing address, I would say. I want to thank the audience for your patience. It's been a long morning. We've had no breaks. I would really like to thank all the panelists, the speakers, for great interventions and presentations. And then just go on to wish everyone a good Thursday. And some of us will move along to continue the workshop. Thank you.